This conference will now be recorded.
My name is Melissa Gentry. I'm the owner of Hill Country Homeowners. So happy to see so many of our board members here with us tonight. Also from Hill Country, we have Michael. Give a wave, Michael.
Good evening, everybody.
We have Tessa. And we have Jennifer. And I think I saw Sierra around here somewhere too. So we've got most of the crew is here today. Just a little bit of housekeeping before we get started. Because we are a little bit of a larger group, we're going to ask that everyone keep themselves muted unless they are speaking. That way we can kind of get rid of any background noise. And also, I'd like to ask you to use the chat in your window. It's the one that kind of looks like a conversation bubble. So if you just put that in there, any questions that you may have, I'll go ahead and I'll bring those up. If it's something that's not relevant to the topic that we're talking about at this time, I'll hold those, and then at the end we can go ahead and answer those questions that weren't relevant to the topic that we were on that time. Because it is a lot of information that we're going to need to be sharing, and there's going to be some questions involved with that, so we want to make sure that you get all of the answers that you need. Also, just in the interest of time, the legislature this year favored the, or not favored the POA, the HOA, more than it did the condo associations. There's a lot more regulations that go for the POAs, the associations, and not the condo. So just in the interest of time, we did put all the condo information up in front. So if once we get to the end of the condo information, if you guys don't have any need or want to listen to the rest of it, that's perfectly okay too. But with that being said, I'm going to go ahead and introduce our attorneys. I see Casey and Tom. Is Bill there too?
Actually, no, it's just me and Casey today.
Okay, great. Well, I'm going to go ahead and turn the floor over to you guys.
All right, hello everyone. I'm Casey. I'm the newest attorney of the Chris Law Firm, and I'll be presenting today with Tom Plaisher.
Good afternoon, everybody. My name is Tom Plaisher. Associate here with the Chris Law Firm. Bill couldn't be here tonight. Bill and myself both each have 20+ years doing HOA and condominium work in South Texas. And again, before we start, we want to thank Melissa, Hill Country, and the entire staff for giving us this opportunity to talk to you and share some information and hopefully to assist y'all making some decisions moving forward. Thank you.
All right, so we're attorneys, so you know we're going to come with some sort of disclaimer. We just want to let you know that this presentation is just meant to be educational. Like Melissa said, there's a lot of new laws that passed. We're not going to dig into the nitty-gritty. We're just going to summarize the main points, what we think you guys need to know. We do encourage everyone to go and read the new laws, but we're just going to summarize the main points. This isn't meant to be legal advice. This isn't meant to create an attorney-client relationship that doesn't already exist. So if there's something specific that something applies to your association and you want a little bit more info, you know, please reach out to us, reach out to Melissa, and we're happy to address these specific concerns. And we can go to the next slide.
Okay. These laws and statutes are brand new. Some are already active. The majority won't be active until later on this year and a couple next year. Now, the advice we're going to give you tonight is based on our experience and our understanding of the statutes and going through legislative notes. These statutes can be read and interpreted different ways. Some of these statutes are pretty broad. The state legislatures, the senators up there didn't get HOAs and COAs a lot of favor. They left a lot of room out there to be interpreted in different ways. Again, and our interpretation tends to be more of on the conservative side. Our goal is to keep the associations and their boards out of court. So our interpretation tends to lean towards being more conservative than liberal. Okay, so we'll move forward to the next slide.
All right, so on that, we're gonna jump right into it. This is just a summary of the main bills that passed that pertain to COAs and POAs. Like Melissa said, there's very few that's just COA only. A lot of it is related to POAs. Going to the first one that relates to COAs, we have Senate Bill 318. This adds a section to Section 82 of the Texas Property Code. So that means this is one of those COA only ones. Now, under this new law, condos are now required to make the books and records available to owners. Owners can request to either inspect the documents, or they can request copies of the documents. And this section does provide guidelines on how the owner must make this request. And of course, it doesn't apply to attorney files or something that pertains to an individual owner. For example, collections, covenant violations. You know, a random owner couldn't just make a request to see those documents. This is just general association documents.
And the reason why it's important for COAs to adopt this policy, HOAs are already aware of this, is that this policy allows the COA to bill the homeowner in advance for expenses, time, and labor and materials. If you don't have such a policy in place, then you don't have the ability to request payment from the owners. So this gives the association the ability to recoup some of their expenses. And that's one of the reasons why it's important to have one in place. Again, this should be in place by September 1st, 2021.
Just real quick, in general, if we, as we go through these slides, you're going to see there's a lot. We recommend you adopt this policy, or we recommend you adopt these certain guidelines. Anytime we make a certain recommendation, that's something that we are going to be able to assist you in adopting. So just keep that in mind. We're not sending you off and, hey, go draft your records and production policy. This is definitely something that we're going to assist with. And also, as it pertains to this slide in particular, like Tom mentioned, these policies have already been required of HOAs for quite some time. So if you're on an HOA board and you don't think that your association has adopted these policies, we can also make sure that we get you compliant with those as well. So while this new law only pertains to COAs, it has already been required of HOAs for quite some time.
Yes, I'll just chime in from the practical standpoint, in that, you know, we've been doing this for about 10 years for homeowners associations. These policies that we have that we've been using them for a decade. So they've been well tested. They've been well, proven to be reasonable. They've been upheld in any type of case law that needs to be out there. And for condos, I mean, it also kind of protects you guys from that homeowner when they get mad and they say, I want to see all the association's documents. Well, at this point, you could say, well, here's, we've got 20 boxes of them, and this is how much it's going to cost to reproduce them for you. So it really gives you a little bit more of ability to make sure that the request is being reasonable and that it's not just someone who's trying to make more work for you because they don't like a decision that was made. I did have a question here from Fidel about what is the policy retention time. I believe it varies. Well, it does vary based on the different types of documents, but do you guys want to speak to that?
Yeah, it does vary on the type of document. For example, your financial books are retained for 7 years. Your owner's account records are retained for 5 years. And again, it varies on the type of document, and that's what's dictated in your document retention policy.
It'll be spelled out for you. I don't see any other questions going on through here, so I guess we can move on to the production policy. Are we on to religious items now?
Oh yeah, I think we'll move on to the next slide, which is the religious.
Great.
Senate Bill 581. Again, a version of this was previously enacted, I believe, back in 2012. They've expanded this now to prohibit an association from disallowing an owner for displaying religious items on their property or dwelling. Okay. Previously, there was a size limit, 25 square inches. That restriction has been removed. Now, there's very few limitations that HOAs now can enforce. For example, display cannot threaten public health and safety, and it can be penalty offensive. Okay. Now, this is one that's probably going to result in litigation. Okay. And your board members probably can envision, and you probably already know a number of homeowners who are going to push the boundaries on this one. Okay. what's a religious item, what's reasonable. We can foresee people putting up their lights year round, and now they can say, well, that's a religious display. Okay, they can put up a 7-10 foot cross in their front yard. That's a religious display. I mentioned previously, someone can build a treehouse in their backyard, and they can call that an altar. That's a religious display. This one may end up in the courts, and the courts may have to provide some guidelines as to what's reasonable and what may be allowed in a subdivision, okay, or even a condo association. So there's going to be a lot of room for interpretation, and there's going to be homeowners who are going to push the boundaries on this. So expect that moving forward.
I'll add on there that I think one of the most important points is that it does not define what is a religion either. So there's no definition of what is a religion. Does it have to be recognized? But it doesn't say anything. So there's really the opportunity for people to claim anything as a religion, and say that this is their religious display item. So there really isn't any guidelines around that. I haven't seen any questions come in yet. So go ahead and put the questions in if you guys have anyone, because I know this one is going to be one that we're going to have to do some talking about as individual boards.
Yeah, again, this is a poorly drafted statute, and unfortunately, it's going to result in eventually some litigation. Okay, no question. We can move on to the next slide.
Nathan wants to know if the owner will still have to complete an ACC request.
No, unless there's a policy in place that requires that, yes. But even then, it's very little the board can do to refuse a display, religious display of most types, unless it's one of the few that there are limitations again, and it's family offensive, threats public safety.
Okay, that was it. We can move on.
Okay. This is House Bill 1281. I don't know if it's going to apply to a lot of our condominiums or HOAs, but this one is actually a change to the transportation code, and which references POAs, and what it said that owners can now operate golf carts in subdivisions, even without golf cart license plates. Very limited restrictions. It must operate them during the daytime, and they must be within a 2-mile radius from the golf cart is usually parked. Okay. Again, this is really a change to the transportation code, which only references HOAs. Any questions?
If we back up a little bit, I did get a couple more religious display ones that came in. I know that this unlicensed golf cart one is a pretty simple one. There's not a whole lot of associations that are going to need a golf cart policy, but there's a couple. So Brooke wants to know, can a fence be considered a religious display?
Can a fence be considered a religious display?
Right.
I think that's going to be discussed later on in the fence statute, as a security privacy fence statute that was enacted as well. Again, just depending on the manner the fence is constructed, there's a possibility that the owner can make an argument that it is a religious display. But again, if it crosses into the fence area, then there's certain things that the HOA can do, assuming they have a fencing policy in place.
Yes, and we'll get there. I've got one from Caleb here too. What can we do as an HOA about religious displays that are offensive, such as language or someone pushing the boundaries? I've got the language up here, right? I'll read it verbatim. They may regulate items that threaten public health or safety, violates a law other than the prohibition of display of religious free speech, contains graphic or language patently offensive to passerby for reasons other than religious content, and is installed on a common area or association property, violates building lines, easements, or setbacks, or is attached to a traffic control device, lamp, fire hydrant, or utility pole.
Again, the courts are going to have to interpret what is patently offensive. What's really a religious display. Again, they didn't give a lot of guidance. They didn't give a lot of language, which will allow an individual to determine what would be across the line, what crosses the line, and eventually it may require a court of law to make that determination.
Great, Thanks for backing up a little bit on that one. Okay, we can go on from golf carts.
Okay, so Senate Bill 6 discusses exposure to pandemic disease. Can't imagine why they enacted this. So this actually adds a section to the Civil Practice and Remedies Code, but it mentions COAs and POAs. So that's, you know, the way that it pertains to us. And it says that individuals and corporations will not be liable for exposing someone to a pandemic disease unless, you know, there's a sick person who knew they were sick, they didn't warn anyone, they didn't try to remediate the situation. So a person almost has to try to get others sick to be liable under this new bill. We do recommend for our associations to adopt a pandemic policy. And there are certain policies that we're recommending our boards adopt. And it's not so much, you know, like with the religious displays, the association isn't going to have a lot of range as it pertains to that policy. And this one is very similar. There's not a lot of range to regulate necessarily, but we still recommend adopting these policies just to ensure compliance with the code. It also provides your owners notice to what's going on, because we just think your owners are more likely to read a policy that you're going to adopt and publish to them versus they're not going to go flip through the Civil Practice and Remedies Code to find out what's going on. So there are certain policies that's more so just to be to give notice and be transparent with your owners. And this is one of them. This bill did go into effect immediately. So this already applies to your HOAs and your COAs.
I have a question here from Jamie. Will this relax our concern about folks using the pool and other community amenities? I can tell you from a practical standpoint, and I'll let them weigh in on it. The major concern with the pandemic and pools was that your insurance policy doesn't have any coverage for a pandemic, and that also includes the cost to defend. So this bill didn't affect the insurance policy, it just affects the association. So there still would be that concern with cost to defend if someone did bring a claim. But I'll let them kind of weigh in on what they think the legal implications would be with that.
Yeah, I agree with Melissa. And just, you know, there hasn't been a successful filing related to pandemic exposure in Texas, okay? Because as a practical sense, it's almost impossible to determine when someone had picked up COVID, much less was in a subdivision's pool or clubhouse. What this strictly is a measure to put out there at a minimum a policy which would at best allow the association to say, hey, we took the measures we deemed necessary and put it forth for our members and the public.
Terry has a question if this will only apply to common areas.
Only those areas that are responsibility of the association.
All right, that was the last question on this, so we'll move on to the next one. The biggie.
All right, now we're gonna talk about Senate Bill 1588. Like Melissa said, this is the big one. There was many sections. Some are actually repetitive of other bills that have passed. So we're just gonna go over the really big changes that require the most effort on our part. And most of these, this is where we're getting into the sections that only apply to property owner associations. I believe we have one that mentions COAs as well, but this is where we're focusing on our HOAs and POAs. So with that, we'll go to the first section. This one talks about swimming pool enclosures. It adds section 202.022 to the Texas Property Code. Associations cannot prohibit an owner from installing a swimming pool enclosure on their property. The association can regulate the appearance of this enclosure. However, it specifically says if there's an enclosure with metal frames and transparent mesh panels, the association will not be able to prohibit that. Essentially, this enclosure is meant to not be climbable. So if someone has these black metal frames, transparent mesh panels, the association would have to let the owner keep it. And on the next slide, so we do recommend that our associations adopt a swimming pool enclosure policy, and this will allow the association to regulate the appearance. Again, we have those minimum guidelines that cannot be prohibited, but otherwise, if the association does want to try to have some sort of regulation over these enclosures, you really want to make sure you get a swimming pool enclosure policy adopted. And this is one that's going to take effect September 1st, 2021.
I read that specific language about the black frame and the mesh. I thought that's oddly specific. And then I started to think about it. And if you think about like the cages that you see around pools in Florida, and some of those other climates like that, where they've got the cages that are meant to keep out, mosquitoes and things like that. That's what those would be. I don't think it's going to impact us here in Texas. And we'll never say never, though, in this business. But if you think about it, if they have one of those cages, what's going to happen the first time a hailstorm comes? It's going to destroy that whole thing. So I don't think it's real practical for us in the hill country. But we might be able to see them. You never know. Does anybody have any questions about the swimming pool? What we should allow, what we shouldn't allow? Again, these will be defined by your specific association. We'll dig into these deeper and customize it for you.
Yeah, in this regard to Senate Bill 1588, provision regarding security measures. Again, this is one of the provisions, one of the new statutes moving forward that's going to provide a lot of heartache and going to raise the ire of a lot of members of the association, and it's going to cause a lot of confusion within subdivisions. And this is one that I predict is going to eventually end up in several rounds of litigation as well. And what this refers to is an association cannot prohibit an owner from installing security measures, including security cameras, motion detectors, and/or perimeter fencing. Okay, association can prohibit the installation of a security camera in place other than the owner's property, and may also regulate the type of fencing. Again, in respect to POAs, for the most part, it has to be on the owner's property. Again, the question I've been hearing with some of my boards: what if it goes over to the neighbor's property, neighbor's backyard? Okay, that's not covered by the statute. Okay, that's something that's may have to be litigated. As long as it's on the owner's property and it's in a reasonable location, it's probably going to be allowed. There's going to be some issues regarding privacy, again, that may have to be litigated. Okay. Now, with regards to the perimeter fencing, this is a hotbed issue. Okay. This is one that the boards are going to have to focus on, and we strongly recommend that they have a fencing policy by September 1st, 2021. Absent a fencing policy, it's going to be the wild, wild west out there. A homeowner can put anything up in their front yard because if you don't have any restrictions in place, there are no restrictions. Now, as far as the restrictions, the association can take into consideration aesthetic concerns, okay, i.e. Fence height, color of fencing, wood type, traffic and visibility concerns, okay? So there are some legitimate things that the board can put into a fencing policy as long as they're reasonable, okay? Again, this to me, this is one of the hotbed ones. This is a policy that the board is going to have to put a lot of time and effort into and ensure that it's in place by September 1st of this year. Any questions regarding the security measures policy issue?
Nothing's come up yet, but I would say that this one kind of is similar to me, that like the religious display item, because it does not define what is a security measure. So what is a security measure? Is it burglar bars on the doors? Is it guard dogs? Is it, it could be anything. So that's why the policy is going to be very important, that we define what is reasonable and what's acceptable.
Can we go back one slide?
I'm sorry?
Can we go back one slide, please?
There you go.
Oh, this includes front yards.
Yes.
Yes.
Oh my gosh. Okay, thank you.
Thanks, Terry. I recognize your voice.
Again,
Yeah.
that's what we stress. This is going to be a hot bid issue because it does include front yards, and again, and that's why it's important that the more than any other policy, I strongly urge boards to put a lot of time and consideration to make sure this policy, if none of the other ones are put in place by September 1st.
This is scary.
Mhm.
It is very scary. It is.
Thank
Okay.
you.
No other questions? Go ahead and move on, and maybe if something else sparks, we can kind of circle back to it at the end.
Okay. So the next section, this amends 209-002 of the Texas Property Code. This defines what a management company is. And it's defined as a person or entity established or contracted to provide management or administrative services on behalf of a property owners association. And this is important, and I italicize person because now with this new definition, on-site managers can constitute a management company for the purposes of the code. And I know most of y'all here are with Hill Country, so of course you have a traditional management company that you would normally think of when you would read that. But I know we have some that may not have a management company yet, so just be aware if you have an on-site manager, this could apply to you. And that's important because on the next slide, there are certain provisions, and we're going to talk about some in a few slides, that only apply if the association has a management company. So before, you might read that and think, oh, I don't have a management company, that doesn't apply to me. But you might have an on-site manager. So now these certain provisions that say only if you have a management company would apply to you. So just keep that in mind moving forward. And this does become effective September 1st of this year.
Okay, so I think we're looking for a little bit of definition regarding an on-site manager. So would this have to be someone who is actually on site, or it could be someone who maybe does accounting for them?
Yeah, typically, an on-site manager is somebody that's employed by the association to work on the association property, i.e. a clubhouse or an office.
So instead of an association, for like I said, most of y'all have already contracted with Hill Country. You do have a management company, but some associations, instead of contracting with a management company, they will hire just one person to act as the property manager. And yeah, like Tom said, a lot of times they'll work out of the clubhouse, or sometimes they're off site, but they are hired directly from the association and not through a company. But for purposes of this new definition, even that one person would qualify as a management company in the code.
I don't see any more questions. I think we're good to move on.
Okay. Senate Bill 1588 with respect to resource certificates. Again, the majority of this is handled by your management company, except for those who are self-managed. And all this does is amend section 207.003 and 207.004 of Texas Property Code and caps the amount of fee that an association can charge for a resource certificate, and that is now $375. Okay. And it's HOA can charge an additional $75 for an updated resale certificate. Now, a question that's been asked: can we charge more for an expedited resale certificate? And the answer is no. You cannot exceed the $375 cap. Okay. One thing of note, again, for those that aren't managed by a management company, you must deliver the resale certificate within 5 business days after the owner's second request. And the reason why it's important is because if you failed to do so previously, the owner could go and seek a judgment against the association for $500. That cap has now been raised to $5,000. Okay. Again, this is for those HOAs primarily who don't have a management company and are self-managed. Otherwise, your management company would take care of this for you. Any questions regarding this issue?
Now, I'll just weigh in here that our resale certificate fees are way less than $375 already. So it's really not going to be a change in business for us.
We can move on.
All right, talking about,
Title company is not considered an owner. Just to reply to that question, Ms. Gurley.
all right, so talking about online websites. This amends section 207-006 of the Texas Property Code, and this one specifically applies to POAs with 60 or more lots and or a POA that has a management company. And I put a star because like we talked about a few slides ago, this, you know, if you have an on-site manager that you wouldn't have previously considered a management company, you would have thought that this section didn't apply to you. But now with the new definition, it would apply to you. And this section now requires HOAs or, you know, associations, they must have an internet website that is available to all of the members, and it has to contain the most current versions of all of your dedicatory instruments. So that's your declaration, your bylaws, any policy that you have adopted, all of the current versions must be available on this website. And it doesn't have to be open to the general public. You just have to make sure it's available to all of your members and owners in the association. And this is one on the next slide I talk about. So what does this mean for the association? And just make sure if you don't have a website already, you do. And like we said, most of y'all are already with Hill Country, and Hill Country's website would satisfy the requirements. Melissa, if you want to expand a little bit on that.
Sure. I've got a question here from Monique. Yeah, but to Casey's point, yes, our website would be just fine. We've got all the documents that are relevant already loaded on the website when someone logs in. You know, all of the forms are there. They can access their accounts. So this is really not going to be a change in business for anyone that's with us right now. We'll just keep continuing the process that we have right now. This would only apply because I know we do have quite a few self-managed companies that or self-managed associations that do come to our training classes just to keep themselves up to speed. And of course, they're always welcome here. So this would be more applicable for them rather than our customers.
And what was the question, Melissa, that came in the chat?
Oh, Monique, their association has 55 homes.
Oh, okay. So then this would not apply. But if they're already with Hill Country, I would imagine their docs are already on your website. So
Brooke wants to know if we have our own website. Should we just get rid of it, or should we get rid of it and just use Hill Country's site?
That's a business decision for the board to make. Don't need to have two compliant websites. If you're already paying for your match company, they have one for you, and that should be sufficient.
Yeah, the only thing I could see from a practical standpoint is perhaps if some information was listed on one site and not on another, could that call into some question legally if there was some, you know, if it was ever brought into contention.
yeah, I agree. I would just recommend having one and keep one updated and consistent instead of having to flip-flop between multiple websites.
I do have a question that came just straight to the organizers. Does this mean a board member access would be available to all homeowners? Speaking from our website, no, absolutely not. Our software has the ability to distinguish who's a board member and who isn't, and the board members have much more detailed access than the regular homeowners do. The regular homeowners have access to requests, their bill, pay the bill, read the documents, submit a maintenance request, those types of things. But when it comes to the individual reports that drill down to homeowner basis, that is only available to board members. You're welcome. Thank you.
Okay, I think we can move on.
Yes.
All right, this section talks about management certificates. It amends section 209-004 of the Texas Property Code. So in addition to the information that's already required to be in your management certificate, now you must also include any amendments to your declaration. That recording info needs to be on your management cert now. Before, you just needed your property manager name and mailing address. Now you're required to include their phone number and email address as well. That website we just talked about, that information is required to be on your management cert, whether it's Hill Country's website or your own website. As long as that information is on there, it's compliant. And then you're also required to include the amount and description of fees relating to property transfers. So like we talked about that cap on resale certificates, that pricing info is now required to be on there as well. And again, this is a change that's really going to apply to the management company and us. We'll be working together to make sure they're compliant. We just want to make sure our boards are aware of the new changes. Now, the biggest change, not only do you have to file your management cert with the county in which your subdivision is located, now you're also going to have to file that management certificate with the Texas Real Estate Commission. So moving on to the next slide, we'll go over the deadlines. So within 30 days of filing, if you amend your declaration and you file that with the county, within 30 days of doing that, you have to update your management certificate with that filing information, file that in every county in which any portion of your subdivision is located. This part of the statute is effective September 1st, 2021. Now, as far as filing your management cert with TREC, they have a deadline. It's not on here, but their deadline to publish their procedure and how you're going to go about uploading that, they're going to publish those guidelines December 1st of this year. And then we have until June 1st of next year, 2022, to file it with TREC. So we have some time before this one takes effect. But once it does, like I said, so you file your amended deck, within 30 days, you file your updated management cert and with the county, and then within 7 calendar days is when you must file that updated management cert with TREC. And again, this is a big one for the management companies and for us, but it's important that you guys know and you're aware, because there are some really big penalties that the association could face if they fail to comply. So for example, if you don't file your management cert with the county or with TREC, the association could be prevented from collecting attorney's fees in a collection matter. And as you guys know, that could be a huge hit on the association. So this is a really big one that we just want to make sure everyone's on the same page, and moving forward, we're complying with the new requirements. And I think we had a few questions pop up for this one.
We did. First one from Lisa is, what are amendments to the declarations?
An amendment to the declaration is a change, in most cases approved by the membership, i.e., for example, allowing a fining policy or allowing a towing policy or establishing a parking policy. It's adding something that wasn't in the original version of the declaration. That is what an amendment is.
Okay, and then the next question I have, are these statutory requirements the responsibility of Hill Country?
It's ultimately the responsibility of the association, because the association is the one that would be held liable and face penalties. But like I said, when you contract with Hill Country, this is, and Melissa, you know, take over where you feel necessary. But Hill Country and us, we're going to be working together to make sure that we're filing correct and compliant management certs.
From the practical, implementation perspective of this, we are going to rely on your attorney, even if it's not Casey or Bill or Tom, but we're going to rely on the attorney, because in the past, the management certificate didn't require that we list all those individual policies. So maybe there were some policies that were, some associations that were enacted, decades ago. So maybe there are a couple policies that are out there floating around that we're just not aware of. So we want to make sure that we're, doing our due diligence, that we're digging, that we're using our legal expertise to help us make sure that we're including all that on that management certificate, so that we have a good, clean one going forward. So if we do make any changes going forward, all we would need to do is just amend the one that we know has been established properly, compliant with the bill right from the beginning. So that's going to be our process in order to make sure that we're staying compliant, that we're getting all those policies in there, and so that we do avoid any of these huge penalties, because that's certainly not what we want to happen.
And this statute applies to both self-managed and professionally managed associations.
I've got a question here. Are declarations the same thing as covenants?
Yes, those terms can be used interchangeably, yes. So it's essentially,
And then Brooke wants to know who files the management certificate. We can file it, you can file it, or the attorney can file it, basically. We just have to have a process, and we'll get that involved. And generally, we let them file it. The fee's the same no matter one way or the other, but they have the ability to file them electronically much easier than we do and faster. So a lot of the times we use them just to file them just solely because they're faster. And then the other one, does this bill apply to self-managed? We already addressed that, right? It does.
Yes.
Yep. No more questions. We can move on to the next slide. Okay, this portion of Senate Bill 1588 refers primarily to the ACC committees. And what this does, and it's again, this applies to POAs with 40+ lots. If the association is still under declared control, then it does not apply to that subdivision. And what it essentially says is that current board members after September 1st can no longer serve on the ACC, nor can their spouses or individuals that reside in the same house as the current board members. Another change that they've enacted will be that ACC denials are now appealed to the board of directors and not to the sitting ACC members. Okay, so that's a big change. And those denials now henceforth must be in writing. They can be sent via email if the owner has approved email communications. That denial must also include the basis for the denial. It must also outline an owner's right to appeal to the board. Okay, we can go on to the next page. Right. Owners have 30 days to appeal. The board has 30 days to hold a hearing. A hearing notice must be sent at least 10 days before the hearing. Each side is entitled to one continuance. Audio recording is permitted, and the board may affirm or reverse the ACC's decision. Okay, with respect to this, people asked about now you're required to submit an evidence packet. Okay, with respect to that evidence packet, it doesn't have to be expansive. It doesn't have to be the evidence you would provide in the court of law. Okay, our suggestion that it be minimal at best. Pictures, maybe a statement from neighbors, provide enough supporting evidence to substantiate that there is a violation and that violation is of concern to the association. That's simply what's required. Again, it doesn't have to be expansive. It doesn't have to include everything in the association's file. If there's names attached to the ACC's file regarding neighbors who have complained, that information can be redacted. Okay, so you don't have to include names and phone numbers of people who have raised concerns or have complained about a violation. Okay. Any questions regarding provision?
Yeah, I got a couple of questions coming in, and basically they're kind of the same thing. So if you're on the board, you can't be on the ACC. That we would need to have an entirely separate set of volunteers. Yes, is the answer.
One thing I might add, this does not apply if an ACC doesn't exist. Okay. Somebody asked me that question just the other day. What if we don't have ACC and we only have a board that makes all the determinations? It's our interpretation that this only applies to those associations that have sitting ACCs.
Question. Oh, go ahead. I'm sorry. I didn't mean to interrupt you. Go ahead.
And somebody asked the question, well, we don't have enough volunteers other than board members. That's a legitimate concern. The legislature didn't address that issue. What if we can't get somebody to sit on the ACC other than board members? That wasn't in their notes. That wasn't mentioned as part of the process. We don't know. That's a question we don't know. Our suggestion is if that situation arises, then have the board of directors make those decisions. And if somebody complains and if they want to go to court and they want to litigate them, then we can say, Judge, if you want to appoint people to the ACC, you're more than welcome to do so. We don't have individuals willing to serve on an ACC, and that's the reason why we don't have an ACC.
So we do have another couple questions coming in here. So our POA only has 26 lots. So this rule, ACC rule, does it apply to us?
That is correct.
But it is possible that there are third-party companies that do provide the service. We did check it as a management company. We could provide that service for you for a fee. So there are other options here that we can explore. Maybe it's a hybrid where Hill Country does all the work as far as compiling everything together, and then we have a couple of members from the community that go in and kind of weigh in and go, yeah, I think what you guys got there sounds good. So it's going to take a little bit of work. It's going to take a lot of work to recruit those volunteers.
And then, again, and this is going to rely primarily on guidance from your declaration. Some declarations require members of the ACC to be members of the association. A majority of them don't. So as Melissa said, you can hire a person who's not a member of the association sit on the ACC. It could be a member of the management company. It could be somebody associated with the accounting firm for the association. Again, we're going to have to read into what the intention of the state legislature was when it passed this provision.
And this does become effective September 1st, which isn't that far away. So if you think you're going to have trouble finding volunteers, we recommend you try finding those, start seeking out, posting advertisements, see what kind of feedback you can get. But we definitely recommend starting that process now, as September 1st is right around the corner.
From our practical standpoint, we've already created a form on our website that's ready to go to solicit volunteers. After we have this, our first meeting together as a board where we start to review the policies, then we can come up with a game plan on how are we going to communicate all of these changes to our members. Maybe we need to have a town hall. Maybe we send a letter or an email blast, but we're going to work out what works best for your association. But just know that we are already working on plans to make sure that we do have a continuation of the ACC, because of course we know that's very important. We wouldn't want anything to auto-approve because there was no one there to approve it. Okay, our declarations make the ACC the board unless delegated. That's nil now.
Yeah, I guess I'm trying to interpret the question, but if you don't have an ACC and the board performs that function, then it's our interpretation that this actually doesn't apply to the board.
Yes, and it is 60 homes or more.
Yes, that's correct. Yes.
And this is one that we'll have to look at on a case-by-case basis. So we'll want to make sure that we'll sit down with your documents and we can have Bill or Casey or Tom show up at one of the meetings, and we can get all of our questions in advance. That way we're really minimizing the time and expense that is going to be needed as we go forward and we implement all these policies and changes. But we'll get there. We just have to take it one step at a time.
Okay.
All right, I think we can move on.
All right, this section governs the notice requirements for board meetings. So before, whether it was a regular board meeting or a special board meeting, you had to notice with 72 hours before the meeting starts. Now with regular board meetings, they have to be noticed 144 hours before the start of the meeting. So that's a 6-day notice period. Special board meetings, they didn't change. They're still 72 hours. But it was the regular board meetings that required additional notice. So moving forward, just make sure your notices, and again, Hill Country would assist with this, making sure your notices are sent timely. We do want to caution our boards that this isn't meant to, the special board meeting notice that stayed at 72 hours, we don't want y'all to use that to circumvent the 144-hour requirement for general board meetings. So still hold your regular board meetings, do your 6-day notice, and then if you do have a special board meeting, you have your 72 hours. But we don't want you guys to use the 72 hours as a way to get around the 144. And this will start September 1st, 2021.
Can the agendas be more generic? It will be hard to do that far in advance when things happen closer to 72 hours.
Agendas don't have to be specifically dictate exactly what's going to be discussed, but they have to provide in a general nature enough information for a member to ascertain what in general is going to be discussed. Okay, so our recommendation is to be as inclusive as possible, but you don't have to be detailed word for word as to simply every single item, but just provide enough information for somebody to determine this is a topic that's going to be discussed at the meeting. This may occur at the meeting. Provide enough information for a homeowner to make that determination.
I have a question here. What is the difference between a regular and a special board meeting?
A regular board meeting is what is required typically by your bylaws and or declaration. Some HOAs are required to meet quarterly, some monthly. So a regular board meeting would fit the definition of what is required in your governing documents, and that usually is located within your bylaws. A special meeting is a meeting that's not dictated or something to be held on a regular basis by your governing documents, and that's usually something that's has an issue, to cover an issue has arisen. It needs the special attention of the board of directors. Was it foreseeable? So say for instance, emergency funds need to be raised for repairs. The board calls a special meeting to discuss that. Those type of things that are required, that were foreseen in your governing documents.
Practically, just kind of think about it. You know, what happens when someone starts painting their house bright purple, right? So we need to call a board meeting right away in order to make sure that we're addressing this. So it's not your regular business where you're talking about the financials. This is something that's kind of come out of the blue, and we need to get it taken care of really soon. All right, I think we can move on. It's got a lot to go.
Okay, this provision of Senate Bill 1588 refers to association contracts. This amends section 209.0052 of the Texas Property Code and applies to POAs only. And what this is, associations must solicit bids in accordance with the bid process for contracts in excess of $50,000. Now, what this means for the association, there's a couple of different interpretations on this one. This is not necessarily a policy that the association has to adopt and file. However, it's our recommendation that such a policy be formulated primarily for the reasons of transparency and uniformity for current and future boards to rely on. Okay. Again, that's just to allow transparency so members know this is a process the board's going to utilize to request bids. Now, there's a different interpretation out there that says that it can be done on an individual project basis. For example, say you have a big project coming in, the board can meet and pass via resolution saying we have a bid going to go out. This is our process for accepting bids for this project, and pass it via a resolution. Again, it's our recommendation that opposed to doing it on a piecemeal basis per project, that you have a standard policy that can be put out there so bidders can say, hey, what's your policy? And you can provide us, this is our bidding process. This is our bid process guidelines, okay? So again, this is effective September 1st, 2021. Any questions regarding the association contracts or the bidding process?
I don't see any questions so far, but this one is another one that's pretty generic, kind of like the religious items and the security measures, where it didn't specify, you know, what are the parameters for this? Is it an annual contract? Is it a one-time contract? So it's really, there's not a whole lot of parameters there. So I think the policy is probably a good idea.
Yeah, it's pretty expansive. Say, for example, the association buys a piece of equipment, and that equipment is going to require installation. Well, that's a service. So, and if it's an excess of $50,000, then you're going to have a bid process established. So there's not a lot of clarity or in this provision or statute, but you can read into it what's going to be required. And again, we'd rather err on the side of being more conservative as opposed to being a liberal reading of the statute.
Haven't had any more questions come in, so I think we can move on.
All right, so this changed the notice requirements for 209 letters Instead of having to give owners 30 days to cure a delinquency, they're now given 45 days. And this is something that Hill Country will do. You know, they usually send out your 209 letters, and Melissa, like you said last time, and I'm sure you'll get into it this time, in practice, it ends up being more than 30 days anyways. It's usually 45, sometimes longer. We just want to make sure that the notices themselves are complying and they say 45 days. So if you already have a collections policy, we recommend amending it to make sure it states 45 days, or we recommend adopting one if you don't have it already, which you'll see in a few slides that the collections policy we're recommending for a few reasons, but for purposes of this section, with the deadline, the notice requirement changing to 45 days, we want to make sure all 209 notices getting sent are reflective of that change.
Casey's absolutely right. It really doesn't change our process at all, other than to amend the date on the template. We routinely offer wait more than 30 days because, you know, we all know that some people procrastinate and they don't mail it in until the 29th day before, the 30th day. So we don't want to go through the process of sending them to an attorney right away when we're going to get a check or a response 2 or 3 days later. So we always wait a little bit after that date anyway. So that may extend it a little bit longer than what we're normally doing, but it's really no big of a change for us. So I think this one's easy to go forward on.
No question, we can move forward to the next slide. Okay. This portion of Senate Bill 1588 refers to those associations that utilize a credit reporting service. This applies to POAs only. And this provision stipulates that delinquent accounts may not be reported to credit reporting services unless certain requirements are met. Most importantly, the owners must be sent a valid 209 letter, a detailed ledger, and an opportunity to enter into a payment plan. Again, Hill Country and the majority of the most learned management companies already do this for your associations. One important note. Go ahead, Melissa. Go ahead.
Oh, so there's no change for us. We already do this anyway.
Right. And again, and one stipulation that's important, that if there's a pending dispute with an owner, their account may not be sent to a credit reporting service. Again, this is for those situations where a credit reporting service is utilized as part of the collection process. Yeah, we can move over to the next slide. Essentially, what does this mean for the association? If you have a collection policy that doesn't include these changes as part of it already, we strongly urge that you modify and you amend your collection policy. And we're going to explain later on why it's important, because this portion of Senate Bill 1588 becomes effective September 1st, 2021. So any existing policy that you have that are affected by any of the changes that are going to become effective September 1st, it's imperative that those policies be amended and replace those currently existed, and this be done by September 1st, 2021.
We have a couple questions coming in. Do all of the sections of Bill 1588 refer to HOAs with 60 homes or more, or only certain sections?
Certain sections. Some refer to 40, some refer to 60. It's not uniform.
We're going to send you all some information that's sort of like a cheat sheet for all this, and it'll specify if it's 40 or 60 or whatever it belongs to. So we'll have all that information available for you. And I know you were going to talk about this towards the end, but for coincidence, I've had the question pop up a couple times. Are you going to provide us templates for the policy, and the policy changes?
Yes, we absolutely will. Yeah, like Melissa said, we have a slide at the end that we summarize any recommendation we made for a policy or guidelines, anything like that. We have a slide at the end that summarizes that, and yes, of course, we will provide templates. We're going to get those sent out. Again, some are merely for notice. There's not a lot of regulation the association can do. But then there are going to be some, for example, the fencing policy, you know, that's going to take a lot of work with Hill Country and the board, so we can make sure and tailor that policy to fit your association needs. If there's certain materials that you want to allow and prohibit, or colors, that's where we'll get into that. So we're going to provide templates. We've already started working on them, and then we'll make sure, you know, any policy that you want, that you're interested in, we're going to make sure we're circulating that with enough time to work with you guys, make the changes you want to make, and then we can get those filed and ready to go with the September 1st deadline in mind. So yes, we will definitely provide templates for any policy we've recommended.
Yes, and we'll be scheduling board meetings. They've made Tom and Casey have made a commitment to have it to us by the end of the month for sure. So we're going to start scheduling those board meetings, right? You know, probably the next week or the week, well, next week, so that we can get those all on the schedule and we can start knocking them out in case we need to have 2 board meetings, you know, to amend things again. But we've got a plan. We're ready to go, and just get ready to clear your calendar so we can get a board meeting going.
And respect to this portion of Senate Bill 1588, I think I briefly talked about it in regard to the ACC hearings, but this regards to covenant violation hearings. Again, this is a POA only statute. If the owner requests a covenant violation hearing, the association must send the owner an evidence packet at least 10 days before the hearing. Again, as I said previously, this evidence packet doesn't have to be expansive. It's not the evidence required in a court of law, just enough evidence to support that a violation does in fact exist. Doesn't have to include names and phone numbers of people making complaints. You can provide a letter of complaint. You can redact the address of that owner making the complaint. You can redact any private information. Our recommendation is that you provide just enough evidence in that evidence packet to support the existence of a violation. At the hearing, the association shall present first, and then the owner can respond to the association. We go on to the next slide. Again, this is a new process, a new type of hearing. Our recommendation is that boards practice the conduct of such a hearing, i.e. establish a hearing script or a checklist or a template for the evidence packet to be sent to the owner. This is not a policy that the HOA has to adopt. It's simply a resource for the board to use. This is how we're going to conduct the evidence hearing. So essentially, say script or a checklist. Have we done this? Have we done this? Have we done this? Okay. Again, and then we're going to discuss in a few minutes why it's important to follow the process. Again, this provision of Senate Bill 1588 is effective September 1st, 2021.
Yeah, so practically speaking, I think most everybody on here has had a covenant violation hearing in the past. So the way it normally works is you go in, and the homeowner is usually upset because they got a violation letter, and we try to use the hearing as a way to diffuse the owner and to come to a compromise where the owner is compliant with the documents, but they understand why it was in violation before. So usually what happens, something like you would sit down and you would go, okay, so you would sit down and just kind of let the owner vent and get everything off their chest, let them know exactly what they're feeling. And then at that point, you could ask questions and go back and forth. And then we would dismiss and the owner would go away. We would talk amongst ourselves and then make the decision. This puts more structure around the process. And it kind of takes away that, that friendly letting them diffuse in the front, because we're giving them all the information. We have to talk at them first versus the other way around. So I think it's important that when we communicate the violation hearing, we let them know that this is a process that we're following. So set the expectations in advance that this is how the hearing is going to go. These are the steps that are going to happen. So it's going to take a little practice to get used to this new format, but we'll be able to do it, I think.
And the reason I think it's important to have a checklist, because if you fail to provide the evidence packet at least 10 days prior to the hearing, then the homeowner is granted an automatic 15-day postponement of the hearing. Okay. So again, that's why we suggest that the boards adopt a checklist or a script to make sure they're following the process correctly to avoid prolonging the process. Any questions regarding this portion of Senate Bill 88?
Haven't seen anything coming through so far, so I think we're okay to move on.
Okay.
All right, the Texas legislature decided, let's go ahead and throw a bone at the associations. Let's give them a little something. So this, now associations can request information regarding a lease or a rental application. So now the association can get contact information for the tenant. They can get the terms of the lease. You know, when does this lease start? Is it a year lease? Is it a 6-month lease? Now the association is entitled to all of that information. And this is helpful because if the association or Hill Country doesn't know that a certain home is being rented and they're sending notices to the owners, owners are never getting it. But now you have the tenant who's in the home. You know, you can make sure you're contacting everybody. You have everyone's information. If there's a covenant violation, you're contacting the person who is at the home. And this becomes effective September 1st.
We're really happy about this one. Just so you know how it works behind the scenes for us, we do have the ability to mark someone in our software as a tenant. So they have limited access to the website, but they can log in to see violations. They can see community documents. Of course, they can't see any of the owner's billing information or anything like that. But it also allows that tenant to know that there is a violation. You know, because many times not all owners, or if they're you know, with a rental management company, they don't always translate the message down to that renter that there is a violation. Maybe they don't know that they're not allowed to have their trash cans out on Tuesdays. So this allows us to communicate more with the renter, and also we can invite them to community events if we have their contact information. You know, make them feel like they're part of the community as well. So I view that this is a really good thing. Fidel wants to know, how do you know if the owner is renting the property, or how can you request a lease application if the owner is not telling you? I can't think of a real easy practical way to do it.
Yeah, I guess you have to depend on neighbors, traffic in and out of that property. If they don't volunteer that information, it's difficult to make a determination on your own.
All right, one more biggie, right? Here we go.
I know they gave us a bone and then they took it away. So this section now, and you know, we've been going over these changes in 209, your notice requirements, their period to cure, and it's really important that the association follows all of those guidelines after September 1st, because this section now allows owners to bring a lawsuit against the association for any violation of 209 in a justice of the peace court. Excuse me. And that's really important because a JP court is much more accessible than a district court. And this change is one-sided. So owners can sue associations in JP court, but that doesn't mean the association can go and sue an owner for any 209 violation. It's just owner to association. And like I said, JP court is much more accessible than a district court. So a lot of times, all of the costs and fees and the effort it takes in a district court it's a disincentive to the owners. So this really can open up the floodgates for owners. And I think Tom can expand a little bit more on JP court.
Yeah, what this bill did, for lack of a better interpretation, is the state legislature threw chum in the water. Okay, and this allows owners to go after associations and individual board members for violations of Section 209, and that's why we stressed earlier that it's important that you work with your management companies, your property managers, and your attorneys to make sure that you're in compliance with all the new changes. Everything's in place by the deadlines, so you don't run afoul of this provision of Senate Bill 1588, and you don't give these homeowners an opportunity or a reason to race over to JP court. Now, to give you a little history or a background on JP court is essentially a small claims court. Okay, it has limited jurisdiction and can only cover certain topics. They're capped in JP court to damages up to $20,000. And as Casey said, this opportunity only applies to an owner. A HOA doesn't have the same opportunity to go to JP court and sue an owner, usually in this provision on Senate Bill 1588. If a decision goes against either party in JP court, an appeal is sent to the county court, okay? And that's done on a de novo basis. And essentially what that means is that if it gets appealed to a county court, it's as if nothing occurred in the JP court. That county court judge hears everything from the beginning as if this is the first time it's ever been heard in court, okay? Again, we stress that to avoid this entanglement, please work with your management companies, work with your property managers, work with your attorneys, and ensure that you're in compliance with all the statutes and all the provisions and all the changes and all in place by September 1st, 2021. Any questions?
Ralph would like to know, can a board member as a volunteer be sued individually over covenant violation complaints? If so, will board members be advised of this change?
We're going to cover that in our next slide.
Okay. We'll have to circle back for some of these and the rest of the changes, but let's go ahead and finish up this topic, and then we can kind of circle back on that.
We added the slides after our last few board meetings because after the discovery that now you can't be sued in JP court, board members want to know what's our liability, okay? I've been doing this for 20 plus years, and over these 20 plus years, I've only seen 5 instances of board members being held liable in a court of law. 3 of those instances resulted in criminal charges. The other 2 instances resulted in board members disregarding the advice of legal counsel, disregarding the advice of other board members, and their behavior was flagrant, blatantly in disregard of all the restrictions or language in their guidelines, in their bylaws and restrictions. Okay. And additionally, to leave some of your fears, there's a Texas Charitable Immunity and Liability Act of 1987. That's commonly referred to as the Act. And that says essentially that any member of a volunteer or charitable organization is immune from civil liability for acts done in accordance with their duties as a director or an officer. We can go over to the next slide. Okay. And essentially, you can read this, but essentially what it says is that as long as you act in good faith, as long as you act in a reasonable manner, and as long as you act in the same manner as you would handle your own business affairs, then you're safeguarded. And it's going to be extremely difficult to be held liable in a court of law. Okay. And remember, there's a provision in 209 that says that, if we go over to the next slide, if you act in accordance or based on the guidance of professionals, i.e. legal counsel, a certified public accountant, an investment banker, or someone that you reasonably believe possesses professional expertise in a matter, then you're going to be held to be acting in a reasonable manner, and it's going to be extremely difficult, if not impossible, to find that board member in violation of this provision and to be held liable in a court of law. So there's a number of safeguards. You really almost have to in order to be found liable, you actually have to be detentful and borderline on criminal. And again, I've only seen it happen maybe 5 times in 20 plus years.
I'll just weigh in here as well that if you are managed by us, we do require you to carry a directors and officers policy, and that will provide insurance coverage for your actions as a director or an officer in the association. And that does include the cost to defend it. In addition, some of you have crime policies. We have, we're bonded, we have a crime policy. So there is a lot of coverage here around this. If you have any specific questions regarding coverage, you can always invite the insurance agent for that policy to come to a board meeting and just spend 5 or 10 minutes talking about the different coverages, what's applicable, if there are any exclusions, what those would be. But there is protection here for you around this.
Okay. Yeah, and remember the key phrases: as long as you're acting in good faith, with ordinary care, and in a reasonable manner, then you're going to be okay. Any further questions?
That was the only question I see coming through on that one. So we can kind of summarize the policies, and then we'll follow up on any questions that didn't get covered while we were going through the slides.
I think the one question that popped up, it was pretty lengthy. I didn't get to see the text of it.
The most recent one that I got, well, this one it's not related to the previous slide, but Brooke is asking why all the changes. You know, what precipitated this since we haven't had major changes since 2011.
Read the newspapers. This is the most activity that's occurred since 2012. And just to let you know, from a historical perspective, a lot of what's occurring is based on abuses of POAs and HOAs, primarily northeast and southeast, up in the Houston, Dallas area. The HOAs up there tend to be a little bit more tenacious in their enforcement. So that raises the ire of a lot of homeowners. So a lot of what occurs over there eventually makes it over into Austin.
Okay. But go ahead and summarize everything, and then we'll ask if there's any more questions. So while they're summarizing, if anybody has anything that wasn't covered, go ahead and put it in the chat. We'll make sure that we get it answered before we end up in tonight.
And just to let you know that there was a ton of other material that was covered up in Austin this past legislature session. A lot of things that did not pass. Again, there's a number of representatives out of Houston who would love nothing better to do than abolish HOAs. But just a few things that were discussed that did not pass were covenants that will restrict the growth of fruits and vegetables. What did not pass is a restriction on the keeping of 6 or fewer domestic fowls. Another provision that did not pass, or essentially that did not pass, was a restriction on keeping of 6 or fewer rabbits. Another thing that did not pass was the raising or keeping of 3 or fewer beehives. Okay, so that gives you the idea of what may become fodder in 2 years.
All right, I know we're going to circle back to the questions, but just as you can see, this is a summary of all the policies and guidelines that we have recommended. Like I mentioned earlier, we've already started preparing templates for these. We're going to make sure we circulate them with enough time. We can amend what needs to get amended and make sure we're tailoring them to each association's needs. I know you're dying to know, well, how much is this going to cost, right? That's your big question. So we're going to offer a la carte pricing. Let's say you just want one of these. You don't want a ton of them. So we'll offer pricing for each one. It's going to change depending on which one you want. It can range from $250 for a policy. The ones that are going to be more tailored and specific to your association, it could be up to $500 for a policy. But because there have been so many changes and we're recommending so many, we're recommending that you adopt so many, we are going to have package pricing. So we'll get with you on an individual basis. We'll determine which ones we think, and you know, Melissa said y'all are going to have board meetings coming up, so she can help determine which policies each board is going to need, and then we'll work with you individually to determine some sort of package pricing and make sure we work with you guys on that.
And irrespective of the sales pitch, again, our recommendation is that whether you utilize our firm or another firm, please avoid the prospect of ending up in JP court. Utilize your property management your property managers, utilize your management company, get the information necessary to get these policies formulated and in place by September 1st. Okay, I can't stress that enough, is that there's going to be homeowners out there. I follow the chat groups, I follow the homeowners forums. Okay, they're itching to get some of these board members associations in JP court. Don't give them the opportunity. Stay out of there. Work with your property managers, work with your attorneys, and be ready and be prepared come September 1st.
Good points. I mean, we're just going to take everything with due diligence, make sure that we're dotting all the I's, crossing all the T's, making decisions that make sense for your community. You know, not adopting something that's just boilerplate that doesn't necessarily apply for you all. So that's why we're going to be scheduling those board meetings. Like I said, first couple weeks of August, we want to have the policies in place, hopefully by the middle of August. That way, we're well in advance of that September 1st deadline. If there gets some backed up on filings, or we don't want to be the one that's sending it on September or on October, excuse me, on August 31st, one month forward instead of 1 month back. So we want to make sure that we're doing that well in advance.
Yeah, and one of I was stressed more than any other one is get your fencing policy in place. Okay, because come September 1st, second, if you don't have one, things are going to be popping up in front yards. So, and that's the one that's going to take the most time and attention, is formulating a fencing policy that fits your subdivision. So, put that on top of your agenda is our recommendation.
All right, let's cover some of these questions that we missed. And Terry had one very similar to that. I think that applies to that. Aren't we insured? So generally, like we said, the directors and officers would apply. If you want to go over that coverage, we can invite the insurance agent to attend a board meeting, and we can just go over all the scenarios that we have in question.
The key language is that your action occurred while you were serving in the capacity of a member of the board of directors or a ACC member.
Jamie wants to know, this is concerning for our particular community since we have an owner that has made actual threats to destroy the board and the HOA. Ugh. I will say every association has one of those. They do. And sometimes they have two or three. So you're not alone. Basically, you know who they are. They're the squeaky wheel. So we just have to come up with a strategy to make sure that we're protecting the association against, the particular person that we already know who you are. So
yeah, and like I said, I make it a habit to go into the homeowner forums, homeowner chat groups. If you want some insight, go into one of those forums, one of those chat groups, and this is what they're saying. I hate to say that they're formulating guerrilla tactics, but they're preparing for September 1st. So be prepared, be ready, act accordingly.
Does the homeowner association have a lobbyist group? Was there anyone there speaking up for us to our leg? I know it's called TCAA, and I got emails from them daily, sometimes more than once a day. So they were definitely lobbying on our behalf.
There is a lobbying group on behalf of the homeowner associations, a very formidable one. Again, there's a number of proposed rules statutes that tried to go forth, but were prevented by the HOA's lobbying group.
Let's see, next question. Can the slides be emailed to us for further review? Yes, the slides will be emailed to you, and we also recorded this, so there'll be a link for it. So if you want to go back and watch it again, or maybe if some of your other board members weren't able to attend prior to that board meeting where we're going to sit down and discuss all that, having them watch it might be a good idea so that we're all on the same page going forward. Monique wants to know, can an HOA require a background check for renters and buyers?
Yeah, if you don't have a policy stipulating the same, then you probably can't require it. Again, recent case law says that if there's anything that HOA or COA, for that matter, wants to enact, it must be written, it must be put into a policy, and it must be recorded down at the county courthouse. And until that's done, then you can't enforce that specific policy or provision.
Kim wants to know, in the sections that talk about number of days, are these business days or all days?
Typically, not business days, but each day of the week. So if it runs over a weekend, then you count those days as part of the timeline.
From Brenda, is the 209 letter the one that specifies the violation and that a fine will be assessed if not corrected within the 45 days?
Yes, it is. Yes, it is. And again, if you have a management company as excellent as Hill Country, then they've already ensured that they're complying with 209, and that language we put it in the necessary documents.
Looking ahead, after the open carry bill is in effect, do HOAs have any power to restrict homeowners to open carry within the neighborhood?
Actually, that's a statute that was passed. No, as long come September 1st, it's unfortunately going to be wide open out there.
That's pretty much the end of the questions. We do have a bunch of comments. asking about the recorded version and copies of the slides, and yes, those are going to be available for you. And then we have quite a few compliments that it was, I like this one. It was actually more helpful and interesting than I thought. Thank you.
Our viewpoints, our interpretation is conservative in nature and intended to keep you guys out of court, out of JP court, because as everybody knows, the only people that win when you go to court are the attorneys. Okay, it doesn't do the HOAs any good. So our goal is to keep you out of court, give you enough information to allow you to stay out of court, and to give you guidance and what you need in order to be effective as a board member for your association.
Well, I want to kind of wrap up. Hey, I said we're going to try to stick to 90 minutes. We stuck to 90 minutes on the nose today. Great. So I want to thank, of course, Tom and Casey for being here, for sharing all their knowledge and expertise, for being a good resource for us going forward in the future. So we're very lucky to have you as part of our family that we can utilize to go through all of these different policy changes. It's going to be a headache, but we're organized. We've got all the information that we're ready to go, and we're just going to take it one step at a time. And I also want to say a big thank you to everyone who took the time to attend tonight. So thank you so very much. We appreciate each and every one of you. Please encourage your other board members, if they haven't attended, to try and sign up for the Saturday class. That way they can do the interactive questions like you had the opportunity or not. But also after that, we are going to make this recording available if for some reason they're not able to do it. But we'll be in contact. And again, thank you so much, and everybody have a great night.
Good night, everybody.
Good night.
Thanks. Good night.